Hello friends, Namaskaram. Myself is Dr. Dinesh Soni. I am an advocate. In today's class, we will discuss about Section 87 of BNS. Section 87 of BNS is quite important section. Previously, it was known as Section 366 of IPC. It comes into motion when the prosecution succeeded to prove that the concerned accused has induced the woman or compelled her by force to move or to go from one place to another place. The means could be deceitful so that she could be seduced for sex, and apart from that, she could be compelled for marriage. In that scenario, Section 87 of BNS would be applicable. But sometimes it is seen that whenever a girl inter alia accompany you, and inter alia she leave her house as per her own will, and there's a false report by her parents, you might be prosecuted as per Section 87 of BNS. So, whenever the FIR has been registered and you have to contest the concerned FIR, you have to understand the two important judgment, one of Honorable Allahabad High Court and other of Honorable Supreme Court. Judgment of Honorable Allahabad High Court is dated 3rd of Jan 2025, and judgment of Honorable Supreme Court is of year 2018. The citation is EIR 2018 Supreme Court page 2099. In both the cases, it has been specified to constitute Section 87 of BNS or Section 366 of IPC. It is required for the prosecution to show that the accused has induced, so I am going to emphasize on the word induced, or compelled her by force so that she could be compelled to move from one place to another place. And inter alia, she could be seduced to have sex and for the purpose of marriage. So, in that scenario, the concerned accused could be prosecuted. But if in limine the facts are not available, the evidences are compromised, the evidences are concealed, mere factual score, mere submission cannot be a basis for the prosecution or conviction as per Section 87 of BNS. Now, the important question arises whenever we are implicated concerning case under Section 87 of BNS, what we can do to save ourselves from the wrong prosecutions. Can you do five important things? If it is possible for you, don't worry. The steps are quite easier. First of all, we have to take the copy of FIR. We have to read it completely. In usual sense, what I see, simply you engage a lawyer for anticipatory or for quashing. It is not easier task to move for anticipatory or for quashing, more specifically concerning the offences covered as per Section 87 of BNS. So simply we have to read out the FIR, we have to gather the facts, and apart from that, we have to know about our role. If our role is not specific, it is general, it is omnibus, the facts are inconsistent, there is lack of corroboration. Can we have the benefit? Am I right? So on that point, you could proceed and could defend your case. That is very important point regarding the defense mechanism. And apart from that, if the girl is major, I'm coming on point number two. The girl should not be minor because if she is major, she is adult. In that scenario, she could take decision as per her own consent and will. So basically, if she is major and she inter alia accompany you, she inter alia move from one place to another place as per her own will and consent. In that scenario, the prosecution will be on the weakest side because the prosecution has to prove the case. So, if the basic ingredients are absent, or basic ingredients are compromised, or the factual score is not going to support the violation of law, in that scenario, we could have the benefit. Number three, the law punishes only when there is an inducement. So, if the element of inducement is missing, so simply the woman says, I inter alia move or leave my home as per my own will, in that scenario, we could have the benefit. Element number four, if there is any evidence on record that the concerned accused compel the concerned woman to move from one place to another place, but the key point is that the element of compulsion is missing or it is absent. And apart from that, the girl says she inter alia moved from the place as per her own will. In that scenario, we could have the benefit. Last but not least, if the ingredients are absent, means the prosecution failed to prove the inducement, the compulsion regarding the seducement for sex or for marriage. In that scenario, we could have the benefit as observed by Honorable Allahabad High Court and by Honorable Supreme Court. So simply we have to file a representation or memorandum in which we have to specify all the facts, and in case the police is not going to investigate on your points and inter alia going to compel you to surrender or going to arrest you, in that scenario you may avail the remedy of anticipatory bail or for questioning. Because whenever we move for questioning, the court simply asks one question: how you could say that the concerned case is false? So simply we have to be accountable towards our role. So if the reply is given, means the memorandum is given, and apart from that, we have specified that the case is false, we are falsely implicated, we are not having any specific role, the allegations are totally compromised, the allegations are false, we could easily have the benefit. So before moving for the bail or for the questioning, I request all of you to submit your proper reply to the concerned FIR, more specifically in these cases, so that we could show to the Honorable Court that we inter alia gave the reply to the concerned authority, but the authority failed to consider our plea. In that scenario, the chance to get the order in our favor would be on the dominant side. So just follow these steps, and ultimately you may get the remedy in the specific and in the legal manner. So the things are simple, but things are simple does not mean that we could be succeeded at once. Simply, we have to gather the facts in our support. We have to arrange them. We have to structure them so that we could put up our effective stand before the concerned IO or before the concerned court. And apart from that, there is no specific orientation. In that scenario, we could not be succeeded. So I specified you how to proceed and what will be your modus concerning these cases. Soon we will meet in the next lecture. Till then, Jai Hind, Jai Bharat.